The following is a history of the United States of America's takeover by England and their lawyers that took it over, turned it into a corporation, and made you unwitting slaves. The agency representatives of the various United Colonies of North America, via Declaration of Independence, declared their separate and equal station, to which the laws of nature and nature's creator entitle them, formally expatriating themselves from England and/or Great Britain, and repatriating themselves in an orderly fashion into a social compact styled as the United States of America under the legislative assembly known as the United States in Congress assembled. However, most people do not realize that the primary reason for the expatriation and ensuing war was not taxation without representation, but the forced payment of taxes to the king in gold, not paper money. The people in the colonies of North America were flourishing by using their own fiat money system based only on their production, not a gold-based system that could be manipulated by the king. The king could not control the fiat money system and therefore passed a law requiring the subjects of the crown to pay taxes in gold only. The king had most of the gold. The people of the colonies had little. Scarcity increases value. Unemployment ensued and embittered souls cried for redress. This fell on deaf ears, which led to the deployment of the natural powers of the people, from which all political power is inherent. They declared their separation, causing the crown to declare an unjust war on the exercise of the principles of life, liberty, and the pursuit of happiness, as the peoples of the colonies of North America had so aptly declared and laid before a candid world, for the causes which impelled them to their separation. The representatives of the United States in Congress assembled did win the Revolutionary War with England. There was a malfunction, however, in the plans for the United States of America. Money powers were waiting at the gate from the very beginning. Although the British Empire, as a recognized government in the world, lost the American Revolution, the power, finance, structure behind it did not lose the war. The most visible of the power structure identities was the East India Company, owned by the bankers and the Crown in London, England. This was an entirely private enterprise whose flag was adopted by Queen Elizabeth in 1600. This flag had 13 red and white horizontal stripes with a blue rectangle in its upper left-hand corner. The British government became hostile by oppressive legislation and eventually declared war from 1774 to 1782. The East India Company's owners constituted a portion of the invisible sovereign power structure banks behind the British government. They kept control of its holdings in the New World and moved right into the new economy created by New Order through the Social Compact, known as the United States of America. Together, and in close association with, the colonial representatives of the United States in Congress assembled, and their most powerful landowners still maintained control of the New World for the British Crown. The United States Constitution created a new social contract structure of government that was established on a much higher plane than the parliamentary system of the Confederation of the United States of America. It was a social compact known as a constitutional republic, wherein a certain amount of power was delegated to the states, corporations, and franchised by the new order of the social compact. A certain amount was delegated to the agency federal government with the residual power reserved to the signatory parties respectively, the real party in interest, we the people of the United States who either signed the Declaration of Independence, the Articles of Confederation, and the new Constitution of the United States for the United States of America, or were related as a member posterity of such people having been signatory thereto. To no other people did such social compact guarantee any standing of rights or otherwise under the new social compact. The representatives of we the people of the United States, by way of their agency representatives of the United States in Congress assembled, had certain enumerated powers delegated by the social compact known as the Constitution of the United States. So far as the several states party to the U.S. Constitution are directly concerned, the representatives of the United States in Congress assembled may not exercise any power not so delegated by the social compact known as the U.S. Constitution. All power not delegated to the representatives of the United States in Congress assembled by the social contract is reserved to the several states within their respective territorial borders, or to the signatory people thereto, or their posterity thereof, Article of Amendment, the 9th and 10th of the U.S. Constitution. The Constitution was pushed and supported by the bankers through their associates for their own control over the construct known as the United States of America, created by the new social compact. Had the Articles of Confederation been completely adopted and/or reaffirmed, instead of adopting the Constitution, which came about due to the Treaty of Peace with the Crown of England in 1782, the bankers would have far less control than they achieved. The word Columbia. This word, and the following words to be defined in this section, are from Webster's Collegiate Dictionary. Columbia in New Latin means Christopher Columbus. It originated in 1775, the United States. Columbus has the same root word as columbarium and columbine. Columbarium in Latin means dovecote, from columba dove, a structure of vaults lined with recesses for cinerary urns. Dovecote is a small compartmented raised house or box for domestic pigeons or doves, also for breeding. It's also defined as a settled or harmonious group or organization. Columbine from columbina and the Latin columbinus columbos is a small grebe, diving bird, Calanos black. Columbidea is the Latin species of dove. Dove is defined as one who takes a conciliatory attitude and advocates negotiations and compromise, an opponent of war. District is derived from districtus jurisdiction, from distringer to distrain, and is defined as a territorial division as for administrative or electoral purposes, an area, region, or section with a distinguishing character. Distrain derived from distrainen, from distringere to bind tight, more at strain, further defined as to force or compel to satisfy an obligation by means of a distress, and to seize by distress, to levy a distress. It's also defined as from strain from streen progeny, lineage, from Old English strion gain, acquisition, akin to gistriuni gain, struere to heap up, lineage, ancestry, a group of presumed common ancestry with clear-cut physiological but usual no morphological distinctions, inherited or inherent character, quality, or disposition, like a dove, from columba dove. The Columbia faction is an Italian organization and Masonic group, founded by Christopher Colin, who was renamed by the organization as Christopher Columbus, circa 1480s. The Columbia faction's symbol is a black dove. It is also interesting to note that the Illuminati, an Italian Masonic group, was formed in 1776 in America. Both of these groups strictly adhere to their own hereditary bloodlines and purposely do not intermix with other ancestries. The United States consists only of what remains of the 10 miles square granted by the Constitution and ceded by particular states, creating the City of Washington District of Columbia, also known as D.C., and further such acquisitions of its territories, including but not limited to Guam, American Samoa, Mariana Islands, and Puerto Rico. One of the powers granted in the Federal Social Compact is to the United States in Congress assembled in Article 1, Section 8, Clauses 16 and 17, which reads as follows: to exercise exclusive legislation in all cases whatsoever, over such district not exceeding 10 miles square as may, by cession of particular states, and the acceptance of Congress, become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and the needful buildings, and fully make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all the new powers vested by this Constitution in the government of the United States or in any department or officer thereof. Said Congress has absolute described as plenary power. This is municipal, police power, and the like. Where does this Congress have such plenary power? Read again clauses 16 and 17 only within the geographical area of the District of Columbia, and all forts, magazines, arsenals, dockyards, and other needful buildings within the several states. The United States is an abstraction. It exists only on paper. It is a total fiction. It exists as an idea. The various republic states of the Union exist in substance and reality. The United States only takes on physical reality after Congress positively activates constitutionally delegated powers through statutes enacted in accordance with Article 1, Section 7 of the Social Compact known as the U.S. Constitution. The Constitution is bifurcated or separated into two parts. The Constitution was bifurcated. Bifurcated is defined as separated. It bifurcated because it is the separation from the original jurisdiction as outlined in the Articles of Confederation. Article 1, Section 8, Clauses 16 and 17 clearly set this out. Remember, the U.S. Congress does have the right to make all laws regarding Washington, D.C. within the 10 miles square granted, whether equal in geographical size is granted or not, and such other territories owned by the United States. This tiny scope of legislative powers is the only authority as it relates to the United States in Congress assembled when contemplating any people of the various states, or standing otherwise, not signatory to such social compact, otherwise than by either being directly or indirectly related as a member of the posterity to the actual people signatory thereto. The first national bank in the United States. Bank is defined in Black's Law Dictionary that has reference to law and judges, and particularly to water or maritime. One of the first acts that the so-called President, George Washington, did within 2 years of his appointment was to declare an emergency. William Morris, with the help of Alexander Hamilton, Secretary of Treasury, heavily promoted the first national bank, Bank of England, to legislation in order to create a private bank. In 1781, Congress chartered the first national bank for a term of 20 years, with the same European bankers that were holding the debts before the war. The bankers loaned worthless, unbacked, non-secured printed money to each other to charter this first bank. After thousands of lives were lost fighting a war to get control of the wealth of the people and their medium of money, why did Congress contract with the same bankers that started the Revolutionary War in the first place? Very simple. Since the Crown and members of the Rothschild family, as they were commonly known, were the secured party creditors, they demanded a private bank to hold the securities, the assets, of the United States as the pledged assets to the Crown of England in order to secure the debt to which the United States had defaulted. The holders, fiscal agent of the Crown, of the securities, were the private bankers operating the newly chartered bank. So, under public international law, the creditor nation forced the United States to establish a private bank to hold the securities as the collateral for the loan. As throughout history, money leads wherever we let it go unrestrained. European bankers expand. By 1785, it had been rumored that the youngest Rothschild, Nathan, expanded his wealth to £20,000 within a 15-year period by using other people's money, an increase of 2,500%. In 1787, Amschel de Meyer Rothschild made the famous statement, "Let me issue and control a nation's money, and I care not who writes the laws." It has been alleged that Thomas Jefferson stated, "If the American people ever allow the previous banks to control the issue of their currency, first by inflation, then by deflation, then the banks and the corporations which grow up around them will deprive the people of all property until their children wake homeless on the continent their fathers conquered." In 1798, the 5 Rothschild brothers expanded by opening banks in each of the major cities of Europe. Amschel Meyer went to Germany, Solomon to Vienna, Jacob to Paris, Nathan to London, and Karl to Naples, Italy. The War of 1812 and the Second National Bank. The charter for the private bank was for 20 years, or until 1811. What happened in 1812? The War of 1812. What did England attack? Washington, D.C. within the 10-mile square. Here the British burned the White House, Library of Congress, and other buildings. Was the attack by England within the assumed 10-mile square an act of war? No, it was not. Under public international law, what was an act of war was the United States not extending the First National Bank into the Second National Bank to continue to maintain the securities on the unpaid debt. So when the United States acted in dishonor, by not giving the lawful creditor his securities in a peaceful manner, the only remedy available under international public order, recourse to the creditor, was to come in on letters of marque and seize the assets to protect his loan. Did the Second National Bank get approved? Absolutely. After England attacked the nation that was in default, they saw the light and enacted the Second National Bank. This was for another 20 years, which was to expire in 1836. The forgotten 13th Amendment. Attorney, with obligation to the courts and to the public, not to the client, and wherever the duties of his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. All attorneys owe their allegiance, first to the Crown of England, second to the courts, third to the public, and finally to their clients as wards of court. Is it any wonder your attorney never wins a case for you? The acronym BAR stands for British Accreditation Regency. Attorneys are members of the Bar. The American Bar Association is a branch of the Bar Council, the sole bar association in England. All laws today in America are copyrighted property of a British company. All state codes are private, commercial, British-owned law. All attorneys follow instruction from England, twist and turn over their clients to the private law of the bankruptcy. That is their job. That is their pledge to those whom they owe allegiance. By definition, the obligations and duties of attorneys extend to the court and the public, also known as the government, before any mere client. Clients are wards of the court and therefore persons of unsound mind. The original 13th Amendment. There was another important issue involved in the War of 1812. The original 13th Amendment prohibited attorneys and anyone with a title of nobility to hold any public office in America. All the states had ratified this 13th Amendment, except for Virginia. You'll note that the War of 1812 was waged mostly in Washington, D.C. The British burned all the repository buildings, attempting to destroy all records of the new symbols of the social compact known as the United States of America, represented in Washington, D.C. by the United States in Congress assembled. Thus, the War of 1812 was partly waged to prevent the passage and enforcement of the new 13th Amendment. Most book repositories throughout the states were burned to the ground and all records destroyed. There's a famous painting in Washington, D.C. depicting the British boarding a ship after they surrendered. The painting shows the British carrying their rifles as they mounted the gangplank. One must ask, what army is allowed to keep their weapons after they surrender? One must also ask, who really won that war? As a result of the accumulated debt of waging that war, a new bank charter was issued for another 20 years. Andrew Jackson and the bank president Andrew Jackson put an end to this second charter in 1836. Jackson's reasoning was simple. The Constitution does not delegate authority for Congress to establish a national bank. Jackson's rationale has never been seriously challenged, and the Constitution has never been amended to authorize Congress to establish a national bank. Nor, for that matter, does the Constitution delegate authority for the United States to establish corporations, particularly private corporations. There was not a national bank established in America for more than 75 years, until 1913 with the Federal Reserve Bank. Andrew Jackson did an excellent job. What did Congress do with Andrew Jackson? They impeached him. Is that because Congress is made up mostly of attorneys? Who do the attorneys have a title of nobility to? The Crown of England. So Congress is populated by attorneys who are esquires or titles of nobility to the Crown of England. So who does our Congress represent? The bankers, the fiscal agents of the Crown. The bankers hired an assassin to kill Andrew Jackson using 2 pistols, however the plot failed as both pistols misfired. Andrew Jackson violated public international law because he denied the creditor his just lien rights on the debtor. However, the bankers did not lend value, substance, so in actuality they had an unperfected lien, and therefore the law actually did not apply. Andrew Jackson stated, "Controlling our currency, receiving our public money, and holding thousands of our citizens' independence would be more formidable and dangerous than a military power of the enemy." The Civil War in 1860, the Southern states, representatives of the original signatories of the Social Compact, walked out of Congress. This created sine die. Abraham Lincoln was elected president. The South walked out and declared their states' rights pursuant to the social compact known as the U.S. Constitution. Slavery was only window dressing for the Civil War. The war had nothing to do with slavery. It has to do with states. The right of the present living posterity of the original signatories to the social compact to alter or abolish the forms of government that their forefathers established for themselves and their posterity, rights and the national debt to the creditor's fiscal agent, the bankers. The South wanted to be redeemed from the Crown in England. The North wanted to remain under their dominion and their debt. When the posterity of the member states of the South ordered their representatives to walk out of Congress, this ended the public side of the bifurcated Constitution as far as the Republican form of government was concerned. What remained of the government was the private side, the democracy, the remaining mob of illegitimate members of the congressional body of agents who had breached the organic social compact known as the U.S. Constitution, which the beneficiaries of the original signatories of the trust so established for their posterity foisted upon them under the rule of the fiscal agents of the Crown, also known as the bankers. During and after the Civil War, the original 13th Amendment was replaced, and a new 13th Amendment was issued first by executive order, and then enacted under martial law on December 18, 1865. The 14th Amendment was enacted similarly on July 28, 1868. The 15th Amendment enacted similarly on March 30, 1870. President Lincoln, by executive order, proclaimed the first Trading with the Enemy Act. President Lincoln stated, "The government should create, issue, and circulate all currency and credit needed to satisfy the spending power of the government and the buying power of consumers." The privilege of creating and issuing money is not only the supreme prerogative of government, but it is the government's greatest opportunity. Afterwards, Lincoln was murdered because he defied the bankers by printing interest-free money to pay for the war efforts. The 14th Amendment brought the freed slaves, whose previous owners were private plantation owners, and transferred those slaves under slavery of the government. The assumed 10-mile square jurisdiction of Washington, D.C. at any given period of time, the only people in the United States who were under the jurisdiction of the private bifurcated government of the assumed 10-mile square of Washington, D.C., were the government employees and those who created the social compact, and of course those residing as resident and non-resident aliens within the territories owned by the United States and now the former slaves. The former citizens of those living in the southern portion of the social construct known as the United States for the United States of America, now captured, became 14th Amendment citizens by martial law. Their only express and sole privilege was to vote as granted by the 15th Amendment. The remainder of the compact party people of the posterity related thereto could still invoke the power over government through original jurisdiction of the Republic side of the Constitution, only in limited application from any curtailed privilege and immunity affected pursuant thereto by way of the Act of July 27, 1868, now Title 8, USC 800, the Expatriation Act. Thus, the new form of democracy, MOB rule martial law as the government was so styled, operated fully under the authority of private law dictated by the creditor, according to the principles of international public order. United States incorporates in England. In 1871, the default again loomed and bankruptcy was imminent. So, in 1871, the assumed 10-mile square was incorporated in England. The new military social construct of the United States was still operating under the old, familiar known Social Compacts Agency name as the United States in Congress assembled, which used the Constitution as their bylaws. Not as authority under the Constitution, but as authority over the Constitution. They copyrighted not only the Constitution, but also many names such as the United States, U.S., the United States of America, USA, and many other titles as their own intellectual property, and secured such property rights by copyright. This is the final blow to the original Constitution, as applicable to the trust operating under the U.S. Constitution for the beneficiaries of the original signatories of the Social Compact created for their benefit by their forefathers. From here on out, the United States was governed entirely by foreign to the law established by the Social Compact, private corporate law, dictated by the bankers as fiscal agents for the private creditors of the intellectual property which they now held in and under copyright with, the creditors extending the right to use such copyright to their esquires by and through the Crown's British Accreditation Registry, bar international agents, attorneys, in association with the Vatican by treaty as the exchequer of the Vatican Treasury.
More bankruptcy reorganizations. Define the word bylaws. In the year 1909, default loomed once more. The US government went to the Crown of England and asked for an extension of time. This extension was granted for another 20 years on several conditions. One of the conditions was that the United States were forced to allow the creditors to establish a new national bank. This was done in 1913 with the Federal Reserve Bank. Along with the 16th Amendment, the collection of income tax enacted February 25, 1913, and the 17th Amendment enacted May 31, 1913, were the conditions for the continuing extension of time allowed by the creditors for the United States to continue to exist as a functioning entity within the international public order. The 16th and 17th Amendment further reduced the state's power by removing the state legislative right to appoint senators directly. The United States adopted the Babylonian system, that being the most clever way to control the mob of people collectively to keep and control political power, thereby controlling any future attempt by contractual obligations, the ability by the beneficiaries to attempt to overcome and to restore the former system of government to which their forefathers had sacrificed their lives, wealth, and their sacred honor to give them. Whether or not their forefathers' actions were right or wrong, the fruit of their labor still exists, with those of us who still study our predecessors' actions for the benefit of hopefully avoiding the same mistakes. First World War. In 1917, people of all walks of life were again drafted into the First World War, aka World War I, for the sole purpose of the beginning of centralizing global power under a new world order. This was to greatly affect the life, liberty, and pursuit of happiness of all individuals living upon the face of planet Earth, then, now, and in the future. The so-called debt accumulated so that it became impossible for anyone to pay off their debts in lawful currency of the United States by 1929. It also enhanced the War Powers Act that President Lincoln, by Executive Order 100, put in place during his presidency. This War Powers Act was reinforced and became the Trading with the Enemy Act of 1917. The Great Depression of 1929. The beginning of the Great Depression launched in 1929, starting with the stock market crash. The stock market crash moved billions of dollars from the people to the bankers' warehouses, banks. This also removed various forms of cash and/or certificates backed by lawful coinage, gold and silver, of the United States then in circulation for the people's use. Those who still possessed any cash invested in high-interest yielding treasury bonds, driven higher by increased demand. As a result, even more cash was removed from circulation for the general public use. There was not enough cash left in circulation to buy the goods being produced. Production came to a halt as inventory overcrowded the market. There were more products on the market than there was cash to buy them. Prices plummeted and industries plunged into bankruptcy, throwing millions more people out of work and out of cash. Foreclosures on homes, factories, businesses and farms rose to the highest level in history, not only locally but worldwide. A mere dime was literally salvation to many families now living on the street. Billions of people worldwide lost everything they had, keeping only the clothes on their backs. In Europe in 1930, the international bankers declared several nations bankrupt, including the United States. Then in 1933, President Roosevelt was elected and took office. His first act as president was to declare publicly that the United States was bankrupt. He further went on to issue his presidential executive order on March 5, 1933, that all United States citizens must turn in all their gold in return for Federal Reserve notes. This was passed into law by Congress on June 5, 1933. House Senate Joint Resolution 192 of 1933. All the people, whether subject to the jurisdiction or not, deluded by a system of public education, assumed the position of such status of citizenship and turned in all the gold in their possession at that time. Why? Were we United States citizens? No. We were still a sovereign people until that time. We just thought that we were required to turn in all the gold in our possession. Only those people living in Washington, D.C. and the 14th Amendment citizens and the citizens per Article 4 of the U.S. Constitution, the beneficiaries of the Social Compact, were so required. We were still sovereign, non-members of the Social Compact. We were not under the jurisdiction of the United States of America, which incorporated in 1871. When people turned in their gold, they just recognized and/or volunteered into the jurisdiction of the assumed 10-mile square jurisdiction of Washington, D.C. and their laws, by general acquiescence. Pursuant thereto, such people became 14th Amendment United States citizens by tacit agreement. Their posterity, which include many of us in this social net of subterfuge, were required to deliver all birth registries to the government. In their place were returned certificates of title birth, the title to our bodies, that were then registered by the U.S. Department of Commerce, Commercial Registry, in its subdepartment known as the Bureau of Vital Statistics. This title to our bodies, all of our property and all of our future labor, was pledged to the international bankers as security for the money owed in bankruptcy by the corporate United States. Title 28 U.S.C. 3002. All of this was done under the authority of commercial law, Babylonian law, by and through secured transactions governing security interest in documents of title. All people were not in bankruptcy. Only the corporate United States and the various worldwide governmental corporate nations, constructs that had become the pawns of the international bankers, were in bankruptcy. Through such worldwide social subterfuge and schemes foisted upon all walks of life, most people were duped into believing themselves a party to the various governmental social compacts and thereby a party to the bankruptcy of the various bankrupt nations. All peoples continue to believe now as then that they are each individually and collectively a member of such aforesaid compacts and/or constructs. The foundational truth is far from the illusion peoples suffer under. All peoples have never had now or then a contractual nexus to such compacts and/or constructs. All walks of life have been continually deceived and educated from childhood to believe that they must give sole allegiance to, and for whatever unsound, non-existent contractual reason, to be controlled by those who form such compacts and/or constructs. Remember, however, that it was only the politicians and the posterity of the original signatory members of the Social Compact, known as the U.S. Constitution, and the assumed 10 miles square of Washington, D.C., the United States Corporation, and other such various government constructs throughout the world at the time, worldwide speaking, that went into bankruptcy. It was specifically relative to no other people or social compact, which was not a party to such or did not go along with the social scheme at the time. In the years following the independence of the several colonies in the north of the Western Hemisphere, a close business relationship had developed between the cotton-growing aristocracy in the south and the cotton manufacturers in England. The European bankers decided that this business connection was the Union's and/or social compact's Achilles heel, the door through which the young Republican form of government could be successfully attacked and overcome. The Illustrated University History, 1878, page 504, explains that the southern states swarmed with British agents. These conspired with local politicians to work against the best interests of the social compact known as the United States. Their carefully sown and nurtured propaganda developed into open rebellion and resulted in the secession of the people of the Compact Party state known as South Carolina on December 29, 1860. Within weeks, the people, beneficiaries as the posterity of the original signatories to the Social Compact of 6 Compact Party states, joined the conspiracy against the Union, and broke away to form the new social compact construct known as the Confederate States of America, with Jefferson Davis as president. The plotters raised armies, seized forts, arsenals, mints, and other Union property. Even members of President Buchanan's cabinet conspired to destroy the Union by damaging the so-called public credit and working to bankrupt the Social Compact Union. President Buchanan claimed to deplore secession but took no steps to check it, even when a U.S. ship was fired upon by South Carolina shore batteries. Shortly thereafter, Abraham Lincoln became president, being inaugurated on March 4, 1861. Lincoln immediately ordered a blockade on southern ports to cut off supplies that were pouring in from Europe. The official date for the start of the Civil War is given as April 12, 1861, when Fort Sumter in South Carolina was bombarded by the Confederates, but it obviously began at a much earlier date. In December 1861, large numbers of European troops, British, French and Spanish, poured into Mexico in defiance of the Monroe Doctrine. This, together with widespread European aid to the Confederacy, strongly indicated that the Crown was preparing to enter the war. The outlook for the North and the future of the Union was bleak indeed. In this hour of extreme crisis, it has been said by those who remain anonymous that President Abraham Lincoln appealed to the Crown's perennial enemy, Russia, for assistance. When the envelope allegedly containing Mr. Lincoln's urgent appeal was given to Tsar Alexander II, it has been postulated that he weighed it unopened in his hand and stated, "Before we open this paper or know its contents, we grant any request it may contain." Unannounced, a Russian fleet under Admiral Levitsky steamed into New York Harbor on September 24, 1863, and anchored there. The Russian Pacific Fleet, under Admiral Popov, arrived in San Francisco on October 12. Of this Russian act, Gideon Wells said, "They arrived at the high tide of the Confederacy and the low tide of the North, causing England and France to hesitate long enough to turn the tide for the North." History, if it can be found in truth, may reveal, if the truth ever comes to light, that the Rothschild family was heavily involved in financing both sides of the Civil War. Lincoln put a damper on their activities when, in 1862 and 63, he refused to pay the exorbitant rates of interest demanded by the Rothschild family. Mr. Lincoln issued by executive order, via the new military social construct, a presumed constitutionally authorized interest-free United States notes. Allegedly, for this and other acts of patriotism, Mr. Lincoln was shot down in cold blood by John Wilkes Booth on April 14, 1865, just 5 days after Lee surrendered to Grant at Appomattox Courthouse, Virginia. Booth's granddaughter, Isola Forrester, states in This One Mad Act that Lincoln's assassin had been in close contact with mysterious Europeans prior to the slaying, and had made at least one trip to Europe. Following the killing, John Wilkes Booth was whisked away to safety by members of the Knights of the Golden Circle. According to the author, Booth lived for many years following his disappearance. House Joint Resolution 192. On March 9, 1933, House 73rd Congress, Session 1, Chapter 1, page 83, first paragraph, third sentence, it states, "Under the new law, the money is issued to the banks in return for government obligations, bills of exchange, drafts, notes, trade acceptances, and bankers' acceptances. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation." House Joint Resolution 192, June 5, 1933, states, "One cannot demand a certain form of currency that they want to receive if it is dollar for dollar, as all currency is your credit. If they do, then they are in breach of the contract of House Joint Resolution 192. You have already accepted this contract, and now they must perform. Pursuant to this contractual resolution expounded upon by the corporation, that you are discharging the debt pursuant to House Joint Resolution 192, they must give you a letter of release or payment in full in the form of discharge. If they ask you, Where does the money come from to pay for the items? You should correct them and say, there is no money, because the United States and all municipalities are in bankruptcy, and the only currency that exists is that of all the people's credit. You could also tell them, the US Trust Fund is where all of the people's property has been collateralized to create the credit of their nation. If they appear confused, show them a copy of the 73rd Congress, March 9, 1933, where it says, the new money will be backed by the credit of the nation. It will represent a mortgage on all the homes and property of all the people in the nation. In their own writing, they agree all people in the nation are the creditors. They would be so impressed and shocked that they had actually witnessed a creditor who knows his business, that they in turn would probably conduct themselves more respectful and businesslike towards you. To understand how the money system works today, one must remember the 73rd Congress, March 9, 1933. The money, Federal Reserve notes, will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. The money so issued will not have 1 penny of gold coverage behind it because it is really not needed. Since the national emergency in banking, otherwise known as bankruptcy, occurred in 1933, our money is credit, your credit, backed by your collateral or your promise. When you sign any promise to pay, it becomes money. What is the difference between Federal Reserve notes and the promissory note you gave the bank? They both represent your credit. Only one thing is different. The bank failed to record your promissory note when they recorded the deed of trust. Therefore, it is not registered in the public register like Federal Reserve notes are. Could this be considered fraudulent use of a foreign security? You better believe it is. International bankers pursue their goal. Undaunted by their initial failures to destroy the social compact United States, the international bankers pursued their objective with relentless zeal. Between the end of the Civil War and 1914, their main agents in the United States were Kuhn, Loeb and Company, and the J.P. Morgan Company. A brief history of Kuhn, Loeb and Company appeared in Newsweek magazine on February 1, 1936. Abraham Kuhn and Solomon Loeb were general merchandise merchants in Lafayette, Indiana, in 1850. As usual in newly settled regions, most transactions were on credit. They soon found out that they were bankers. In 1867, they established Kuhn, Loeb and Company Bankers in New York City and took in a young German immigrant, Jacob Schiff, as partner. Young Schiff had important financial connections in Europe. After 10 years, Jacob Schiff was head of Kuhn, Loeb and Company, Kuhn having returned. Under Schiff's guidance, the house brought European capital into contact with American industry. Schiff's important financial connections in Europe were the Rothschilds and their German representatives, the Warburg Company of Hamburg and Amsterdam. Within 20 years, the Rothschilds, through their Warburg-Schiff connection, had provided the capital that enabled John D. Rockefeller to greatly expand his Standard Oil empire. They also financed the activities of Edward Harriman Railroads and Andrew Carnegie Steel. At the turn of the 20th century, the Rothschilds, not satisfied with the progress being made by their American operations, sent one of their top experts, Paul Moritz Warburg, over to New York to take direct charge of their assault upon the only true champion of individual liberty and prosperity, the United States. At a hearing of the House Committee on Banking and Currency in 1913, Warburg revealed that he was a member of the banking firm of Kuhn, Loeb and Company. He said, "I came to this country in 1902, having been born and educated in the banking business in Hamburg, Germany, and studied banking in London and Paris, and have gone all around the world." In the late 1800s, people didn't study banking in London and all around the world unless they had a special mission to perform. Early in 1907, Jacob Schiff, the Rothschild-owned boss of Kuhn, Loeb and Company, in a speech to the New York Chamber of Commerce, warned that unless we have a central bank with adequate control of credit resources, this country is going to undergo the most severe and far-reaching money panic in its history. Shortly thereafter, the United States plunged into a well-orchestrated monetary crisis that had all the earmarks of a skillfully planned Rothschild plot. The ensuing panic financially mined tens of thousands of innocent people across the country and made billions for the banking elite. The purpose for the manufactured crisis was twofold: one, to make a financial killing for the insiders; two, to impress on all people the great need for a central bank. Paul Warburg told the Banking and Currency Committee, "In the panic of 1907, the first suggestion I made was, let us have a national clearinghouse, a central bank. The Aldrich plan for a central bank contains many things that are simply fundamental rules of banking. Your aim must be the same." Digging deep into their bag of deceitful practices, the international bankers pulled off their greatest coup to date: the creation of the privately owned Federal Reserve System that placed control of the finances of the United States securely in the hands of the power-crazed money monopolists. Paul Warburg became the Federal Reserve's first chairman. It has been alleged that Congressman Charles Lindbergh put his finger firmly on the truth when it is proffered that he presumably stated just after the Federal Reserve Act was passed by a depleted Congress on December 23, 1913, "The act establishes the most gigantic trust on earth. When President Wilson signs this bill, the invisible government of the monetary power will be legalized. The greatest crime of the ages is perpetrated by this banking and currency bill. No wonder his son was kidnapped and killed." United States of America. The several states, the people, then got together and began to draw up guidelines for federal government. These were the Articles of Confederation. These articles were ratified but were never truly perfected because there were factions between the wealthy of the new nation, who still had economic and political ties with previous counterparts of the Crown in Britain. Some people wanted to be aligned with England. Their wealth and continued wealth were locked with English rule and commerce. Others wanted to be completely separate from England. Those who favoured England found that there was too much opposition to be bound with England. As a result, those in favour of England, with the aid of English bankers, did the next best thing for themselves. They pushed for a constitution governed by treaty instead of the Articles of Confederation to control the new social compact. The Constitution was completed and established before the Articles of Confederation were brought forward, in respect to Article 6 of the newly finished Articles of Confederation. In 1789, the U.S. Constitution was adopted by several signatory people, and thereafter their holdings became known as states. But a few people states, those being the true people, whom most are unaware of as referred to in the Social Compact as states, of the so-called union or marriage of the states, wanted some protection from the new Social Compact federal system of representative agency government. It took another 2 years for the Bill of Rights to be added to the Social Compact, known as the U.S. Constitution. This was to protect those people signatory to the Social Compact from their agency representations in government, the assumed 10 miles square, and the employees of that government. Never were all people ever invited to sign the Social Compact, but were sold on the assumption that the rights, privileges, and immunities applied to all people, which of course was an absolute lie. The title of United States of America doesn't include the word "the." Just as General Motors doesn't imply a plural number of motors, United States does not imply a plural number of states. There is nothing plural about the contemporary use of the term. United States is a singular proper noun, and correct usage does not include the antecedent definite article. The United States is a corporate trade name like General Motors and identifies a corporation, albeit federal and municipal, but a corporation nevertheless. Just as proper English doesn't include the Canada, the Finland, or the Egypt, it likewise does not include the United States. A far more accurate indicator would be the state of United States. We read of the state of Great Britain in the Declaration of Independence and hear of the state of Israel in the news. The proper recital of the name United States identifies the for-profit, bankrupt commercial enterprise in Washington, D.C., presently managed by the receiver in bankruptcy, Secretary of the Treasury of Puerto Rico, also known as Secretary of the Treasury. The United States is a slyly concocted fraud that plants in the mind the notion that its identity is merged with the states, when in fact it is foreign to the people states. The Republic no longer operates since the fraudulent takeover by declared state of war. See Trading with the Enemy Act after the bankruptcy. This condition is artificial, de facto, and unlawful. It is well established that United States, also known as US, USA, America, government and federal government, etc., is a corporation, originally incorporated February 21, 1871 under the name District of Columbia. It was reorganized June 11, 1878, as a bankrupt organization per House Joint Resolution 192 on June 5, 1933. A de facto government, originally the 10-square-mile tract ceded by Maryland and Virginia, and comprising Washington, D.C., plus the possessions, territories, forts, and arsenals. United States is defined as a federal corporation in Title 28 U.S.C. Section 3002, Chapter 176. It is clear that the United States is a corporation. In the Federal Supplement number 724 from 1776 to 1789. United States was a confederation, and after 1789 it was a singular incorporated federal nation system. The significance of this is that, as a corporation, the United States has authority to implement laws for we the people of the United States, but no more authority to implement its laws against all the people than does McDonald corporations, except for one thing: the contracts we've signed as surety for our straw man with the United States through misrepresentation of by and for the creditor bankers.
These contracts binding us together with the United States and the bankers are actually not a party in interest with us, but with our artificial entity, acting as a transmitting utility, or as they term it, the office of person, which cleverly uses the same descriptive alphabetical denoted letters as the name given to the living, breathing people, privately at birth, but with one difference. The form of identification changes the symbolic alphabetical spelling with all capital letters. The United States as a corporation created in England came under the jurisdiction of England. This entitled England to create laws as England saw fit to do, establish those laws in the United States, and everyone who at that time was a 14th Amendment citizen were subject to obey those laws. This also placed the Congress of the United States above that portion of what we think is the Constitution, not under the authority of the Constitution. Copyrighted, remember? The only Bill of Rights left at this point in 2025 is 4 Amendments 13th, 14th, 15th, and 16th. That is all the courts are required to take cognizance of when any people appear in their courts, excepting those people operating via international public order by way of the supreme law of the land, treaty, within the framework of any form of social compact. The 1929 stock market crash and the Great Depression that followed placed the so-called American people in desperation, homelessness, poverty, and even starvation. The minds of all people were focused on survival. They were then in a condition to accept any handout given by the government, no matter what the cost to their freedoms. All people were drawn in as 14th Amendment citizens by such misrepresentation through the 15th Article of Amendment to the U.S. Constitution and the registration of people's birth records, and in return, handed certificates in exchange for this perfected consideration of the sole and exclusive right to vote under the new social construct of democracy. People were further enticed deeper into that system by volunteering for many other licenses and privileges given by the corporate United States government. We were also made enemies of agency, the United States. This act gave the agencies of the United States authority under the laws of war and as a captured alien people to force anything on them as the corporation chose to create or deprive them of, whether for their benefit or not. Then, in 1976, Congress removed any semblance of justice in their court system with Senate Bill 94-201 and 94-381. As 14th Amendment citizens, the people are not citizens of the social compact known as the United States of America, as we have always been taught to think. We are actually subjects via international public order to whatever jurisdiction which we are found in or reside in, unless we have otherwise emerged into some other political status, freely determined to prove that we the people don't belong to such social construct, to whichever may claim an interest, however defined or by whatever means shown to operate. There is no law today except as relative to such fictions governed by copyrighted statutes, to be interpreted by judges who construe and construct whatever they choose to have those private statutes mean. We, as sovereigns, irresponsibly continue to recognize the illegitimate Crown of England and its fiscal agent, the International Monetary Fund, as principal of all the people on the soil, whether referred to as the United States or by whatever derivative or variation thereof. In reality, the International Monetary Fund was the creditor of the United States, a corporation, but never you, lawfully or legally. The creditor of the United States designed invisible contracts to ensnare the sovereign people of planet Earth as subjects. The creditor of the United States implemented the invisible contracts through apparent color of law, and the sovereigns irresponsibly agreed by way of the education received under misrepresentations. We, as the sovereign peoples of Earth, through the invisible contracts and our irresponsibility to reject the creditors or IMF's ideas, have been duped into voluntarily giving up our substance and energy to the private order of a few well-orchestrated men by way of the mythical creations of corporations affecting our condition and present situation. You'll find that there is a common thread woven throughout our entire history. That thread is commerce, the merchant, the money changer, or banks, the law merchant, also known as the law of commerce, civil law, and maritime law. This is not to say that commerce is bad. It does, from this point forward, the officers of the court can construe and construct the laws to mean anything they choose them to mean. However, say that commerce brings with it the laws of commerce. Wherever commerce goes, it brings laws that can bind people into slavery. This can happen only if the people agree with it, depending upon their condition of mind, either willingly, through misrepresentations, or by mistake. United States is also known as the US, USA, America, United States of America, and is defined as a federal corporation per Title 28 U.S.C. Section 3215A, Chapter 176. It is clear and well settled that United States et al. Is a corporation, originally incorporated February 21, 1871, under the name District of Columbia, 16 Statute 419, Chapter 62. It was reorganized June 11, 1878. A bankrupt organization per House Joint Resolution 192 on June 5, 1933, Senate Report 93, 549, and Executive Orders 6072, 6102, and 6246. A de facto government, originally the 10-square-mile tract ceded by Maryland and Virginia, and comprising Washington, D.C., plus the possessions, territories, forts, and arsenals. The significance of this is that, as a corporation, the United States has no more authority to implement its laws against we the people of all walks of life than does McDonald corporations, except for one thing: the contracts we've signed as surety for our straw man with the United States and the creditor bankers. These contracts bind all people by misrepresentations together with the United States, and the bankers are actually not valid with the true flesh and blood man or woman, but with our artificial entity, or as they term it, person, which appears to be us but is spelled with all capital letters. First, your birth certificate was voluntarily given by your mother through misrepresentations to the state of corporations and then entered into the commercial registry for registration within the United States when you were born. This, in commerce, gave title to your body by way of illicit constructive or other types of contracts. Now, all of us are members by mistake and/or misrepresentations of the Babylonian system in every manner. Next, the government created an artificial person, an organization, a fictitious entity, and what we call an artificial entity and/or straw man. By and through an adhesion contract, the government then made you, the real man or woman, responsible for, fiduciary for, and surety for that artificial entity. This is how your artificial entity secured the national debt, and through it, you became a 14th Amendment citizen of the United States. All licenses and all existing contracts are made between the United States or the state of, in whatever state your straw man resides, and your artificial entity. That fictitious entity binds you to the United States because they have, through adhesion contracts, made you the real man or woman, fiduciary and responsible for that artificial entity and/or straw man misrepresentation, condition of mind, or mistake. All of these contracts you sign carry with them your agreement to obey and uphold all the laws, rules, and regulations passed by the Congress of the United States Corporation and the state of residence and will be enforced against you. From that day forward, we could never own any property because the state now had possession. Of course, you voluntarily sign and even request all those contracts, don't you? In 1964, the state obtained title to our property. We can only rent the homes that we believe we own. We only have a certificate of title to the car we think we own. The state owns the true title to our homes and to our cars, to everything we thought or think we own. You married the state through your marriage license, and your children became wards of the state. All of this was pledged, including all the fruits of our future labor, to the bankers as security against the national debt, and was placed in the possession of the Secretary of State of each state as an agent for the trustee of the bankruptcy, the U. This was further tightened up when we applied for our Social Security number after 1935 by contract, which we hurriedly and voluntarily entered into when the Social Security Act was signed into law. Then, it was further solidified as we entered into additional contracts and applied for a variety of benefits and licenses, all voluntary affairs without full disclosure. States lose sovereignty. President Roosevelt then called all the governors into Washington, D.C. for a conference. This was the beginning of all states losing the remainder of their sovereignty. It was not until 1944 that the corporate states lost all their power over the corporate United States with the Buck Act. With this act, the states became, essentially, 14th Amendment citizens as well. This completed the destruction of the corporate states having any power to protect against usurpation by the U.S. government. The corporate states now were under the jurisdiction of Washington, D.C. The adoption of the Uniform Commercial Code by all states in 1964 and a number of other like laws and acts were incorporated into this nation. This made the Uniform Commercial Code the supreme law of the land. In 1976, Congress took away any semblance of law or justice left within our court system. All law today is now construed, constructed, and made up by the judge as it happens before your very eyes. The military social construct known as the United States, acting through the guise of the United States and Congress assembled, took away any control or authority we might have had over the court system. See Senate Bill 94-204, which deals with their court system and Senate. Bill 94-381 dealing with public law. This has been well hidden from all of us. Why and how the courts can simply override their laws, as we've cited those very laws within our paperwork. It's very simple, now that we know how they do it. They operate on their words, construe and construct. Many of us who go into court often wonder a simple word such as meaning. For example, if you're in the river, you are wet, you can swim, but if you're simple, word can make in change to at, as in at law or in law, has a totally separate at. And the attorneys often change this word when they answer you're the river, you might enjoy a refreshing picnic, play baseball, or run races. You will be paid in dividends when you read the answers of attorneys to your paperwork. Compare what they claim to what their case law says to the actual case law itself. You'll discover that they have actually changed the words therein. This is illegal, you might say. No, not according to the above-mentioned Senate bills. You see, they can now construe and construct any law or statute to mean whatever they decide it means for their benefit. You don't know any of this. You think they are railroading you in a kangaroo court? No, they are contracts, which they are bound to uphold. They usually follow the law to the letter, contract law, legal in what they do, according to the present social compact, their law, private international law, the law of contract, which you know nothing about. Failure to understand the above and realize what law you are dealing with when you go into their court will only lead to failure. Even if you have filed your UCC-1 and have captured your title and your artificial entity, this makes no difference in their courts. Why? They operate in total fiction, in the land of Oz, in respect to any assumed standing which you may, by mistake, think otherwise. Whatever you file in their created social compact, their court, whether it is your UCC-1 or use any of their perceived law which is copyrighted, in the administrative or judicial power of their original jurisdiction inside of their established social compacts or otherwise, is all that is real. Recognize contracts. You are a real sentient being outside of lawful, and credibly in truth to them. They can only contractually speaking. They do not recognize truth of any sort, other than by such compacts or the treaties between such social compacts. They only recognize fictions known as corporations, which they administer and/or contract law governing social compacts and their corporations and such applicable treaties between them. So when you go into any court, be aware that it is their private copyrighted law, that the judge or the prosecutor can construe and construct that law in any fashion they choose. They call this practicing law. It will always mean what they choose it to mean according to the present custom, usages, and practices of the day. So are their courts bound by the Constitution? Law? Statutes? No! Their courts are bound by contracts only and the statutes used to enforce the contracts. When we use their statutes, Constitution, UCC, rules, and regulations, all copyrighted without a license from the BR, we are in violation of copyright infringement, and punishment is mandatory. There is no law in this illusionary nation and state under whatever form or name for which such is known, or the world for that matter. There is only contract law by which the private people, sovereigns, treat with one another in the so-called worldwide public forum, where commerce is concerned, and is the order of the day, known as the international public order, via private international law, between sovereigns and/or their created social compacts and corporate constructs. We can see throughout all walks of life in our collective history that Babylon, or however one wishes to refer historically to an oppressive system of whatever form any social compact of society takes, commerce and merchant law have followed wherever the productive people go. The bankers were waiting in the wings when the founding forefathers established a new social compact for themselves. It was only 2 years after the Constitution was enacted that the bankers threw them into bankruptcy. The newly founded government of the Social Compact moved over to the side under the assumed 10-square-mile jurisdiction their Congress controlled. In 1860, the southern states walked out of Congress as stated earlier. This officially ended the lawful side of the Constitution under a Republican form of government. Due to ongoing breaches of the Social Compact by several of the beneficiaries, within several of the individual Compact Party member states' constructs, and their abuse of the federal branches of the Social Compact designed to forbid such breaches, but instead uphold the breaches to the Social Compact until the Union was reduced to chaos and eventually destroyed and replaced by a new form of republic. See the Gettysburg Address by the attorney, President Lincoln? Not unlike the continued revamping of the 4 or 5 French republics historically, until the bankers had complete control of the Social Compact to their liking. In 1871, the assumed 10 square miles and its territories that Congress controlled was incorporated in England. The Constitution was adopted as the bylaws of their corporation. This ended completely their previous constitutional standing. The beneficiaries of the original signatories, their blood posterity, to the Social Compact no longer had a constitution within the framework which their forefathers had created for their benefit by and through such agencies and offices of trust, honor, or profit, could or would be bound or controlled to the beneficiary's sole and express benefit. The United States as a corporation, created in England by and through treaty, now came under the jurisdiction of England. This entitled England to create laws as England saw fit to do. England established those laws in the United States, and everyone who at that time or would be by such misrepresentations as could be foisted upon the unsuspecting people were and are 14th Amendment citizens. They were and are subject to obey those laws, however defined by their esquires, attorneys. This also placed the Congress of the United States above that portion of what we think is the Constitution, not under the authority of the Constitution. Copyrighted, remember? The only Bill of Rights relative to all walks of life at that point in time were eradicated via martial law by 4 Articles of Amendment: 13th, 14th, 15th, and 16th. This is all the courts are required to take cognizance of whenever you appear in their courts. Next, the merchants of Babylon, the bankers, moved deeper into our nation by the establishment of the Federal Reserve Bank in 1913, and the IRS to collect the interest on their loans made to the United States. The 1929 stock market crash and the Great Depression that followed placed the people in desperation, homelessness, poverty, and even starvation. This orchestrated bankruptcy was not only local, but was carried out repeatedly on a worldwide scale. The minds of all people were orchestrated and forced to focus on survival. They were then in a condition to accept any handout, New Deal, given by the New Order government, no matter what the cost to their fair deal freedoms. President Franklin Delano Roosevelt treasonously placed the beneficiaries' social compact trust entirely into socialism. All walks of life were drawn in as 14th Amendment citizens through the registration of our birth certificates. All walks of life were further enticed deeper into that system by volunteering for many other licenses and privileges without any consideration given by the government to reduce our rights into privileges, and then to be reduced to paying fees for the exercising of such privileges, which could be taken by the state for whatever reason it deems necessary. All walks of life were also made enemies of the United States. This act gave the United States authority, under the laws of war and as an alien captured people, to force anything upon us they choose to create unless one emerges as discussed above. Thereafter, all walks of life sank further into socialistic communism. If you read the 10 Planks of Communism, the Communistic Manifesto, you'll discover that this nation has fulfilled every plank successfully. We are a communistic nation, period. Then, in 1976, Congress removed any semblance of justice in our court system with Senate Bill 94-201 and 94-381. From this point forward, the officers of the court can construe and construct the laws to mean anything they choose them to mean. As 14th Amendment citizens, we the people are not citizens of their social compact like we have always been taught to think. We are actually, each and every one of us, a sovereign of planet Earth, through the unalienable birthrights to which the laws of nature and nature's creator entitled us. Today, as in ancient Babylon, various walks of life have idols of worship, of which money, Federal Reserve notes, represent such as graven images created by people. Both represent a fiction of construed value, for whatever reason any market would bear, based upon conditions of supply and demand. The value established is whatever is given accordingly, relative to anyone's particular inordinate affection of such idols. Today, law has become a fiction of corporate copyrighted statutes, to be interpreted by judges who construe and construct whatever they choose to have those statutes mean. Do you now have a different viewpoint on where you actually are now from where you thought you were before hearing this? Demonstrate to those of like or kindred souls the difference between where you were or thought you were when you began hearing this and where you now know you are in terms of your political, citizen, and legal standing within the social construct known.
Who are you, Messiah?
If this doesn't happen, the human race will die.
Oh, really?
The first commandment is to maintain a global population under 500 million. Do you know what that means? It means 6.5 billion people are going to die at the hands of the Illuminati unless we stop the Iranians from detonating that dirty nuclear bomb at the Hollywood and Vine train station.
The Iranian suicide bomber cell is located at the Vibe Hotel on Hollywood Boulevard.
This isn't Scooby-Doo.
Little blood drinking turned your stomach?
Died of through the bomb. What is this? Fucking Batman and Robin?
I have become part of something that I no longer felt right about serving.
It's Hollywood and Vine, not Vine Hollywood. Don't you know anything about American culture, you silly Russian?
The global military-industrial complex.
Leading the charge of the carnal feminine.
Ah, yes. The Messiah.
My book. It's the solution.
How is that the way the world is?
Traitor, who are you working for?
If I was cartoon character, I'd be Woody Woodpecker.
This land is your land. This land is my land. From the Gulf Stream waters to the New York Island, this land was made for you and me.
As the United States.